Hi, I'm Max Alvarez. I'm the editor-in-chief of the Real News Network and host of the podcast Working People. And this is the art of class war on Breaking Points. The strike is labor's greatest weapon. When the bosses already have the power to hire and fire, when they have the power to coerce and control because they hold our checks and thus our livelihoods in their hands, when they have the political power that money buys, when they have a legal system that overwhelmingly protects their property and commercial interests over the rights and needs of working people, and when they also have at their disposal the vicious muscle of the police, the deck is stacked in their favor. And that, at least in the US, is how it was designed to be. No matter how many politicians, small business tyrants, and Chamber of Commerce bootlickers whine about employers and investors not being able to do whatever they want, and that they have to deal with some, marginal regulations and pesky things like workers' rights. Whether it's dipshits who have never had a real job like Ben Shapiro, or cosplaying shills for big business like Mike Rowe, if anyone out there is trying to convince you that unions are these all-powerful entities and that bosses and businesses are more politically and legally hamstrung in this country than workers are, I promise you they are either lying to you or they are so ignorant about what they're talking about that you probably shouldn't be listening to them. But here's the thing. The deck has always been stacked in the boss's favor. That's been true since the existence of bosses. The people at the top of hierarchical power arrangements are there because they have more power than the people below them. And they wield that power to impose their will, to maintain that hierarchical system, and to fortify their own privileged place within it. That is why the soul of the labor movement is collective, rank-and-file organization and action. There are more of us than there are of them, as the adage goes. And workers' strength, the power they have to counteract the power of the bosses, comes from their numbers and their ability to mobilize and act as a group. That is as true now as it ever was. As the great Big Bill Haywood, a founding member and leader of the industrial workers of the world, famously said, quote, "If the workers are organized, all they have to do is put their hands in their pockets and they have got the capitalist class whipped," end quote. So why is that the case? What is it about workers collectively withholding their labor that tips the scales? Well, it's kind of obvious, but the point is to disrupt production, to disrupt business as usual, to shut shit down, as is workers' right to do if they are being treated poorly and unfairly. Because sometimes that is the only way to get the bosses to listen. If workers can be prevented from causing such disruption, or if their actions can be safely circumvented with scabs and legal loopholes, then their demands can be safely ignored. Our right to strike is the foundation of the whole social contract holding this poor excuse of a society up. If we don't have that right, or the cost of exercising that right becomes such a powerful deterrent that few actually exercise it, then we are just submitting to whatever unelected executives and managers want to dole out to us. We are resigning ourselves to the fate of bugs squashed under the boot of the necessary march towards whatever great future this capitalist system wants us to have. And right now, many eyes within the labor movement are fixed on this rogue Supreme Court, which has agreed to hear a case that could seriously restrict our right to strike, which would have huge implications for all of us who consider ourselves workers or who consider ourselves part of what Richard Wolff described to me as the order-taking class, not the order-giving class. Earlier this month, the justices on the Supreme Court agreed to review a case that had been adjudicated by the Washington State Supreme Court, titled Glacier Northwest, Inc. versus the International Brotherhood of Teamsters Local Union Number 174. We're going to do our best in today's segment to break down this case and its implications without getting too mired in a bunch of eye-glossing legalese. But what you need to know up front is that the Seattle-based ready-mix concrete supplier Glacier Northwest, which does business as Cal Portland, sued the Teamsters Local 174, claiming that a one-week walkout by workers in 2017 involved intentional property damage that the union should have to pay for. According to the union, before drivers walked off the job, they returned loaded trucks to the company's yard and left them running so that the concrete in the mixing drums could be safely unloaded. The company, however, alleges that the union timed the work stoppage so that the concrete would harden in the mixing drums, become unusable, and cause costly repairs. Now, given this court's clearly demonstrated ideological and political mission to further empower employers and the ruling class writ large, and to disempower working people and roll back our rights, there's obviously a lot of fear right now that a ruling in this case could shatter decades of precedent and enable employers to make workers and unions pay incredibly steep prices for exercising their right to strike and for causing the very economic disruption that is, again, the whole point of a strike. To talk about all of this and more, I'm honored to be joined today by Terri Gerstein. Terri is the director of the State and Local Enforcement Project at the Harvard Law School's Labor and Work-Life Program, and she is also a senior fellow at the Economic Policy Institute. Terri, thank you so much for joining us today on Breaking Points.
Thank you so much for having me today. I'm really concerned about this case and really happy to have the opportunity to just to drill down a little bit and explain what the case is about.
Well, again, I really appreciate you taking the time. I know you're super busy, and I'm freaked out about this case too, and I desperately need your expertise here because I know that, you know, like I said in the intro, like our eyes can start glossing over when we get into the legalese here. But, you know, the implications of this case are humongous. And so I was wondering if we could kind of start by just sort of, breaking down, you know, what this case is about. And why, you know, you think the Supreme Court granted it a review.
So in terms of what the case is about, you summarized some of the most important facts. There were workers who went on strike. Basically, the company, Glacier, had a contract that ended, and 11 days later, workers went on strike. And the company makes cement and has special prepared cement that is quick dry. And so if it's not poured within 20 or 30 minutes, it will dry out. And the workers went on strike. The work day is such that some workers start at 2 a.m. when the cement has already been mixed, and they start in staggered times going to 7, and they went on strike at 7 a.m. What happened was the workers then, the ones who were still at the company premises, you know, went on strike, left the cement trucks running so the cement would not dry out. The workers who were out delivering cement brought the trucks back to the company premises, and again, also left the trucks running so the cement wouldn't dry out. If the cement had dried out and the trucks had been turned off, for example, that could have ruined the trucks and rendered them unusable. So what happened in this case, though, was that the company they were able to clean out the trucks. There was no damage to the premises, no damage to the vehicles, but the cement for that day, they were able to remove it from the trucks, but it wasn't usable in the end because the company didn't have a backup plan. It was during active negotiations. It happened less than 2 weeks after the prior contract with a no strike clause had expired. And so, you know, it perhaps would have been prudent for them to have in mind that this was among the possibilities and have some contingency plans, but the cement was damaged. What happened in the court case, the employer filed what's called a tort lawsuit. And, you know, a tort lawsuit is basically a lawsuit for economic damages. It's, you know, someone did you harm and they owe you money for it. And the employer filed a tort lawsuit in state court saying, we lost all this cement and we should be able to sue the union for damages because we lost all this money because of the cement. Now, usually that kind of lawsuit wouldn't be allowed. And this is where it does get a little wonky. It's not allowed because of a concept called preemption. And the whole idea is that the National Labor Relations Act, our federal labor law, is supposed to be it's supposed to be kind of uniform nationally, and states aren't supposed to be allowed to kind of weigh in either in favor or against the union or the employer. The idea is that they kind of came up with this whole scheme, and it's supposed to be all managed at the federal level. And there are a few exceptions to this, like, the classic example is if someone punches someone on a picket line, that's assault, and the state can get involved. So there are some exceptions to preemption. And what's happening in this case is that Glacier is arguing that because the cement was damaged, that's akin to something like vandalism, and so falls outside of preemption, and they should be able to not just be governed by the NLRB, be sort of within the confines of the NLRB and the National Labor Relations Act, our federal labor law, but they should be able to go into state court and file a claim for economic damages. And this is really troubling because some economic harm to employers is implicitly part of what a strike is. That's just part of what happens. That's part of sort of, the cases talk about the economic weapons that are contemplated by the National Labor Relations Act and our federal labor policy. And some economic harm to the employer is what gives workers their collective leverage in a strike. Again, they're not allowed to, take a bat to the front door of the company. They're not allowed to do things that sort of go beyond that normal economic harm. And so what's really troubling about this case is that, arguing that loss of one day's supply is akin to vandalism, or punching someone on a picket line, to that kind of like really intentional property damage. It's really troubling. And the company argues as well that the timing of the strike is part of what makes it fall outside of preemption, that they timed the strike in a way that is like made it particularly harmful because the cement was already mixed and therefore that caused the damage. But again, workers can choose strategic timing for their strikes, and to argue that strategic timing or losing, a day's supply of product, there was no harm to the vehicles, no harm to the premises or anything like that. It's just a very dangerous precedent to think that it would be permitted for the employer to then sue a union for damages, in a way that could be, potentially extremely harmful financially to them.
Right, like you said, like it's really dangerous because that's the whole damn point of these actions, right? I mean, if Amazon workers walk out on Prime Day, there's a very obvious reason why they're doing that, right? And if employers can somehow use and weaponize the courts to say that this is, vandalism that unions have to pay for, that's obviously going to be a huge disincentive for folks to go on strike. And I wanted to sort of kind of build on that here. You already started touching on this, but let's talk a little more about why this matters, right? And what the implications could be, depending on the decision, what the implications could be for workers' collective right to strike. And I mean, are there any positive outcomes that could happen from this?
Well, I think the negatives really far outweigh the positives. There are some positives that I'll talk about in a minute, but when you think about the implications as well, when you think about, the fact that the concrete was quick dry and sort of in a sense like a perishable product, right? There are so many things. Our entire food chain consists of perishable products, right? What does this mean about the right to strike for everyone from food processing workers, restaurant workers, people who make yogurt, people who work in ice cream stores? One of the major cases, in fact, that the union cited in its brief, and I think the Washington State Supreme Court, which came out against Glacier, against the company, I think the Washington State Supreme Court cited as well, dealt with cheese, workers who had walked out in a cheese company in Colorado. The facts of that case are basically the workers wanted to have Christmas afternoon off as they had been promised. And so they walked out on cheese making, and then the cheese was of a lower quality, and the employer made less money selling the cheese as a result. And again, in that case, which I believe was an NLRB case and didn't end up in the courts, but in that case, the decision was that, the fact that the cheese was of a little lower quality doesn't render the strike unprotected by the National Labor Relations Act. So, when you start to sort of spin out like what are perishable products, and even there are products that aren't perishable in the way that food is perishable or quick dry concrete is, but there are different kinds of products and services that are seasonal as well. Clothing and fashion can be seasonal, or, the entire retailers, the entire month of December before the Christmas and winter holidays. But in terms of potential silver linings, this whole issue of National Labor Relations Act preemption, that the federal law, anything that is arguably covered by the federal law, states and localities are not allowed to get involved in. This is something that has been used often by employers to prevent workers from having certain kinds of rights. So, for example, even right now, there's a case going on. New York City passed a law creating just cause termination for fast food workers. That they can't be arbitrarily fired, and they have to have some kind of, job-related reason for being terminated. And that law is being challenged in part on National Labor Relations Act preemption grounds, saying that this is arguably covered by the National Labor Relations Act. And it's, a city shouldn't be able to make this kind of law. And so, reading this case, it's interesting for me as someone, my own background is in state labor law enforcement, and I work with a lot of states and localities. And, we're often having conversations about what are ways that states and localities can actually protect workers without being constrained by preemption. And so logically, if the employer is allowed to sue the workers or the union for damages, for economic damages in state court for striking, logically, that weakening of preemption should create some space for workers to have other now non-existent state and local opportunities for remedies or action that could benefit workers. Could a worker sue for damages for an employer if the worker is terminated in retaliation, and as a result of not being paid wages ends up being evicted, for example? And there's a tort called intentional infliction of emotional distress. Like, are there damages that workers could sue for? Does it open the door for more action by progressive states and cities? So logically, if the Supreme Court were actually going to be consistent, if they were going to loosen preemption and say, yeah, there's a little bit of a wider area that states can get involved in, logically, that should redound not only to employers' benefit in some instances, but also to workers. There's a goose, what's good for the goose is good for the gander issue here. And that prospect, frankly, I think should give the justices some real pause, even the conservative justices, because, I don't think that they're concerned about preserving the right to strike or workers' right to take collective action, but they may be concerned about overreaching by states or workers or unions pursuing employers in various ways. Just given the composition of the court, though, I think it's just really concerning. They seem to be very good at finding ways to thread the needle. In this case, you really would have to thread the needle to say, like, yes, preemption is relaxed, but only for the employer. And, their ability to thread the needle to come to outcomes that are pro-corporate and that are anti-worker, are just, it's been troubling and disappointing, obviously, for several years now. So I'm very, to me, this case illustrates the need, among many other things, just the urgent need to have court reform, because with the Supreme Court we have, it just creates a lot of really bad outcomes on a lot of issues that many of us care deeply about.
Right. I mean, you say if the court, wants to be consistent, that's a big if with this court, right? I mean, and I think that's why we're all so nervous about stuff like this, right? Because we've seen, as you said, that this Supreme Court, like really is wearing its politics on its sleeve. It's making it very clear that it is trying to kind of take the outcomes that the majority of the court already want, and kind of, shoehorn some sort of legal justification to come out the other side with those outcomes. And so there's the obvious kind of point, as you said, about the ideological kind of makeup of the majority of the existing court. But there's also like a thing that I try to emphasize for folks, like the larger sort of system that we're seeing at work here is also very much stacked in favor of employers, of investors, of major corporations, of the ruling class writ large. Because, when the court system becomes so costly and prohibitive and takes so long, right, to kind of move cases through the courts, let alone get up to the level of the Supreme Court, obviously there are going to be a lot of cases that make it there when they can ride on waves of cash from, employer advocacy groups, conservative donor groups, shadowy, PACs and stuff like that. Like, in a lot of ways, the courts are policy making through the side door, right? Because just like the infamous Janus decision in 2018, this case that, the Supreme Court has agreed to hear, right, is it's not like just some mom and pop who like filed a lawsuit and somehow that case made it all the way to the Supreme Court. Like, no, like there are a lot of outside interested parties that are trying to push, like this case all the way up to the Supreme Court and get the kind of outcome that they want. And so I wanted to ask if you could just sort of talk a little bit more about, right, like the sort of, class interests that this Supreme Court is serving. And like, another question I had is, is this something that, the Biden administration or Congress could kind of cut off at the pass with any sort of executive order or legislation?
Well, that's a great question. And your observations about the court are exactly spot on, because in addition to the Janus decision, we've seen other decisions in the last few years that have really shown hostility to worker collective action. There was the Epic Systems case, and in that case, that was, it sort of was written about and understood as being about forced arbitration, and sort of blessing, giving one more blessing to employers forcing arbitration on workers. But the Epic Systems case was really about whether requiring workers as a condition of employment to give up their right to bring a class action, which is inherently collective action, whether requiring employees to give that up violates the National Labor Relations Act. And it's, again, it's a real example to me, as you said, of sort of outcome-based jurisprudence that they came out against, and found that it wasn't a violation of the NLRA. They could have harmonized the Federal Arbitration Act and the National Labor Relations Act, and they chose not to. And then more recently, in the last session, there was a case, Cedar Point Nursery, in which there was California state law. I guess there still is. I don't know the exact status of it, but the California law allowed unions to go onto farms, agricultural job sites for like a super modest period of time, during a very limited number of days per year. And the reason is obviously because farm workers are isolated and vulnerable, and they're working in rural areas and are hard to reach. And so the Supreme Court basically found that this California law was a taking, an unconstitutional taking of the grower's property without just compensation. The reason I say I'm not sure what the current status is that generally if something's a taking, it means that you have to give just compensation. And so I don't know how you calculate just compensation for like letting organizers on for, 30 minutes a a few times during the calendar year. But both of these cases just really show hostility to collective bargaining. But in terms of the question of what Congress can do, again, this case also, as so many things do these days, just to me illustrates the importance of the midterms and how much is at stake. Because borrowing from another area, the Supreme Court had a really bad decision recently, earlier this year, about the Clean Air Act that constrained the Environmental Protection Agency's ability to act in certain circumstances. And Congress, when they passed the Inflation Reduction Act, they basically rectified that and changed the definitions so that now the EPA has the authority to do what the Supreme Court said the prior statute didn't permit. And so there are ways that Congress, if we get a Congress that will actually do, work for working people and really fight for these issues, and we need to make sure that, we need to make sure that we get worker champions in office. Congress would have the ability potentially to legislate in a way that could obviate the bad results of this decision.
Well, and I want to pick up on that quickly, right? And then I gotta let you go because I know you're busy and we got to wrap this up. But this is such a crucial point that I want to stress for anyone watching and listening to this, right? Because I think the situation that all of us are in relation to the current Supreme Court or the Supreme Court in general, right, really crystallizes the dynamics of power in this country, right? Because for anyone watching, regardless of what your politics are, I know that we may be kind of cheering on or lamenting, the decisions that are being made by this court as if they're being somehow made for us, right? Oh, yay, the Supreme Court got, overturned Roe. That's a huge win, for, the people who wanted that to happen, right? Or, you may have been cheering on earlier in the year when the Supreme Court, basically overturned OSHA's authority to enforce vaccine mandates or weekly testing for large employers who have 100 employees or more, right? You may consider that a win for your side. What I want to stress is that the Supreme Court does not give a shit about you, right? I mean, there's a very kind of clear class dimension going on here where you could in fact interpret a lot of these decisions as kind of buttressing the power of the ruling class and disempowering working people, right? Because that is the net effect. Losing abortion rights, who's that going to hurt? Working people, working families. It's going to hurt people's ability to make a living. The number one justification for people getting abortions is financial need, right? I mean, and the EPA ruling that you mentioned, Terry, look at Louisiana. Who are the people who are going to be living in sacrifice zones because it's the only place that they can afford? And now that, corporations can just, pollute the air, water, and so on and so forth even more, who's going to suffer from that? Working people. Even the OSHA case that I mentioned earlier, you may be totally ideologically opposed to vaccine mandates and weekly testing. Fine, I'm honestly too exhausted to get into that right now. But you should know that the justification that was given in that court ruling for saying that OSHA did not have the authority to implement this rule, there are large implications for that because what they said is that COVID is a general condition that is not limited to the workplace. Thus, employers have no special requirements to, increase safety measures for their workers. Now, think about climate change. We did a segment a couple months ago on the heating in UPS package cars, right? As climate change gets worse, employers can point to that same ruling and say, well, the climate problem is a general problem. It's not a workplace problem. So we don't have to do shit to protect our workers who are boiling out, in the agricultural fields or warehouses or package cars, so on and so forth, right? So just think of the implications of these and what they mean for working people in general, instead of getting sucked into this position that we're always in, where we're cheering on one side or the other. And effectively, we are put in the position of the citizens of Tokyo cheering on Godzilla or Mothra and just hoping that they fall on the right buildings. We have no influence here. We are very much at the mercy of a court that is carrying out the interests of the ruling class with these rulings. Terri, does that sound like do I sound completely off there?
Well, one framework that I would add to what you were saying is that a lot of what you're describing and a lot of these problems stem from sort of the logical extension of the 80s and the whole kind of, attacking the public sector and the Reagan era of, the government is bad and we don't need, in the end, what the government is it's, socializing needs and collectively sharing, everything from parks and libraries and hospitals and highways and public transit, which our country does not nearly we don't nearly invest enough in. But the entire sort of dismantling of the state, of regulation, of antitrust enforcement, that's sort of, again, and there are obviously corporate interests that don't want to be regulated, and so I think that's also part of the context of all of this is like deregulation, the free market kind of run amok. And I think also in moments like when we have a pandemic, there are certain situations like when we have a pandemic like COVID, when we have climate change, the hurricane in Florida. These are moments when I think people realize there are situations that we just cannot address individually, and we need to have some sense of collective action, separate from collective action in the workplace, just collective action as the public, as fellow human beings, and that people realize they really do need, we do need the state to play a really important role. And I think there is a danger of thinking about, the important role of the state only in those crisis situations, because there is such a critical role for the state and the public sector in so many different ways. And so I think that's also, a lot of these Supreme Court decisions have just been very anti-regulation, very anti-oversight of corporations. And that's something, again, as you said, that redounds to all of our detriment. People can't really, we haven't figured out a way yet for people to buy their own air. There are collective, there are ways that wealthy people obviously, have options that everyone else does not. But in the end, there really are some collective interests that we all share. And dismantling the regulatory state in this way, not allowing anything from gun laws to environmental laws to workplace laws, that's something that really harms everyone.
So that is Terri Gerstein, the director of the State and Local Enforcement Project at the Harvard Law School's Labor and Work-Life Program and a senior fellow at the Economic Policy Institute. Terri, thank you so much for coming on today and sharing your brilliance so generously with us. We really, really appreciate it.
Thank you so much for having me. I really enjoyed the conversation.
Thank you all for watching this segment with Breaking Points, and be sure to subscribe to my news outlet, The Real News, with links in the show description. See you soon for the next edition of The Art of Class War. Take care of yourselves. Take care of each other. Solidarity forever.
Cable news is ripping us apart, dividing the country, making it impossible to function as a society, and making it impossible to know just what is true and what is false. But the good news is they are failing and they know it.
That is why we're building something new, a new mainstream, a healthier one, something more trustworthy, something that we are going to need in one of the most pivotal times in American history. We are building up here for the midterms, for the upcoming presidential election, but we need your help. So if you can help us out by becoming a premium member today at breakingpoints.com, we're trying to change America for the better and the entire world.
So what are you waiting for, guys? Go to breakingpoints.com and sign up and help us build a new mainstream.